हेलो हेलो।
हेलो हेलो हेलो।
Good morning and warm welcome to you all. I am Vaibhav, your host for today. Our topic for today is succession planning. It shall taken by Mrs. Vijal Bhanushali. She is a chartered accountant at BM Bhanushali and Associate. She shall cover understanding private trust and estimate planning, securing your legacy, awareness, knowledge sharing, and enabling smooth wealth transfer, followed by question and answer session. Our agenda
Hello.
for today is virtual inauguration by Dr. Sundar Kataria, invoking the blessing of Gayatri, chanting of Gayatri Mantra, introduction of speaker, presentation by Ms. Vijal Bhanushali, question and answer session, and last closing session. About Sadgun Sangh. Sadgun Sangh conceived and led by Dr. Sundar Kataria, driven with a mission to elevate the quality, safety, and environmental awareness levels of industry. Sadgun Sangh is a series of educative, informative events aiming to illuminate professionals on possible solutions to current issues of industry and economy. About Dr. Sundar Kataria, designation and organization, Chairman and Managing Director, International Certification Services Private Limited. His academic qualification, Doctorate in Business Management, Mechanical Engineer. His experience, Rajasthan Atomic Power Project, India's first nuclear power plant, RAPP at Rawat Bata, Kota, built by Indian engineers. Work as nuclear scientist for 11 years and successfully completed and commissioned the plant. Engineers India Limited, first batch of engineers to develop Bombay High Offshore Oil and Gas Fields, Mega Offshore Complex Platform, Trunk and Submarine Pipelines, Underwater Inspection, Oil and Gas Equipment, etc. DNV, World Largest Classification Society, worked for 17 years at various capacity for the certification of fixed offshore installations, submarine pipelines, onshore projects, and personnel qualification. ICS. He is founder of India's first certification conformance assessment body established in the year 1999, provider of total quality solution. Certification of management system, that is ISO, inspection, testing and training, qualification of personnel. Achievement and awards. Received Lifetime Achievement Award for the contribution for the corrosion technologies from NES International by NIGIS under NES USA. Social worker, protection of life, asset, environment and safety. Now I request Kataria sir to please virtually inaugurate the session.
कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः.
Please join us for the recitation of the Gayatri Mantra. Introduction of our today keynote speaker, Mrs. Vijal Bhanushali, her designation and organization, partner at BM Bhanushali and Associates, her academic qualification, Bachelor in Commerce, followed by Chartered Accountant, her area of specialization and experience, provide expert guidance in areas such as taxation, GST, litigation, funding, succession planning, RERA, and consulting and advisory. Currently, her focus is on helping individuals plan for the future through effective succession planning. In addition to her advisory work, she is an experienced speaker and has shared her knowledge at various forums, offering valuable insights into her areas of expertise. So please welcome Bijal ma'am. Over to you, ma'am.
Hello, am I audible
Yes,
and
ma'am.
visible?
Yes, ma'am.
Okay. Thank you, Mr. Vaibhav, for such a warm welcome. Good morning, everyone, and thank you for joining us today. Today, we are going to understand some aspects of succession planning, which is often overlooked by everyone in their financial as well as personal life. Succession planning is important for each of us, be it an entrepreneur, a family head, or a professional who has got assets. They all want their assets to get transferred to their loved ones after their death very easily. You do not want your loved ones to go through any hassles as they're already under a lot of emotional distress because of your death, and you do not want to add further distress to your family members. So succession planning is basically a planning, or we call it a procedure of how you transfer your wealth to your loved ones. It can be done through a lot of tools. We'll be understanding basically two legal, widely used instruments, that are wills and private trusts. Both offer distinct roles and there are different benefits for both of them. We'll be understanding each of them, and you will be in a position to take a proper, I think, what we call decision on what tool to go forward with. So, wills provide more of clarity and consistency, certainty for your beneficiaries, and the private trust will offer more of control and privacy for you. So, it is on you on what instrument you want to go forward with. So go forward as per your whims and fancies, like what suits better to you. If you're looking to minimize taxes, avoiding probate, or having a structured plan, the tool will be chosen depending on that. As we explore these options, we'll also look after the legal, financial, and emotional considerations that are involved in succession planning. You all want a smooth transfer of your wealth to your loved ones, so that is important. By the end of today's session, I hope that you all will understand what succession planning is, what are the tools of succession planning, and you'll take a next step towards securing your future and your loved one's future. Thank you again for being here, and let's get started with this journey of securing your legacy. Before I proceed, I would like to emphasize that this content is basically based on the prevailing legal framework and my personal interpretations. I am only discussing what is there in the Hindu Succession Act, which applies to Hindus, Sikhs, Jains, and Buddhists. There are different laws for Muslims, Christians, and Parsis. And this presentation is only and only for the purpose of information. If you want to go forward with your succession plan, it is better that you go with professional guidance from legal experts. It will ensure that you have proper decisions, sound decisions, which are in line with your financial goals. Now, to understand the succession planning, first and foremost, what is important is we understand the basic framework of financial planning. The basic framework of financial planning is dependent on the financial planning pyramid. At the base, we have wealth protection. Wealth protection can be done through risk management, insurance policies, and various legal structures to ensure that your wealth is protected from all uncertainties. Without a strong foundation, all your protection, all your strategy will go in vain. If you do not have a proper protection strategy in place, all other strategies for creating a wealth, distributing will all go in vain. Moving forward, we have wealth creation. This is about actively building in your assets through investments, savings, and business growth. It is where we put in efforts to increase our asset value through various strategies with the goal of creating a comfortable future for our loved ones. Then we have wealth distribution. This is where the role of private trusts and wills comes into play. Today, we are going to specifically focus on wealth distribution itself. This is where how you plan to pass on your assets, your wealth to your chosen beneficiaries. So let's just talk about this wealth distribution today. Now, let us first understand why estate planning is essential for your future. Number one being preserving wealth. Yes, we all want to preserve our wealth, our assets from any mismanagement, unnecessary taxes, or any disputes. You all want to ensure that you have a smooth wealth transfer to your loved ones. Then we have avoiding family disputes as a reason. We have a classic example in our mythology of Mahabharata, where there were family disputes, there was war between the Pandavas and Kauravas because there was no estate planning then. So you also want to avoid unnecessary family disputes, that yes, you should go forward with estate planning. It will ensure when you have a proper, clear documentation in place, it will ensure that there are no family disputes in the first place, right? Then again, providing for your dependents. It could be your spouse, your dependent parents, your minor children, or maybe specially able children. So you want your dependents to be free of any worries about their financial future. To secure their future, you have to go for estate planning. You, by way of trust, you can ensure that there is consistent flow of income to your dependents in case of unforeseen circumstances. Then for tax efficiency, by proactively managing your assets, you can minimize tax liabilities. There are ways you can structure the trust, like what form of trust you're going forward with, which will help to efficiently manage your tax liabilities. Then for financial independence, I would say that you would want to enjoy your life and have control over your assets throughout your lifetime. And you would want to have that control in your hand, that to whom your assets should be passed on after your death. You do not want a court administered guardian for your minor child, or you do not want some court appointed asset manager, right? So you have to have a estate planning. Then we have peace of mind. Yes, peace of mind is the most important, I guess. If you want to actually enjoy your life without any concerns about your future and your loved one's future, you should definitely do an estate planning. When you know that your loved ones are financially secure and your wishes are legally fulfilled, it will give you a lot of peace of mind. Okay, so what is the process for having an estate planning done? Number one, you will have to assess your assets and liabilities. So what are your assets? You could have financial assets such as bank accounts or other investments. You could have personal assets such as jewelry, vehicles. You could have real estate assets such as land, building, or so. Then you should also know about what your liabilities are. You should actually know what loans are associated to their assets, what you are actually going to transfer to your beneficiaries. So it is important for you to assess your assets and liabilities. Then define your goals and beneficiaries. What your goals are, as in what do you exactly want to do with your wealth? Do you want to give it away as charity? Do you want to give it away to your kids, your family? Who are your beneficiaries? You need to identify them. you need to actually understand what is to be done with your wealth, right? So, do you want to get it transferred to someone immediately on your death or maybe at a later stage? So, that you have to define right now. Then you should choose the right estate planning tools. You could choose any of the estate planning tools like wills or trusts. There are a variety of trusts. We'll understand them at a forward stage. So you could choose any of the trusts form suitable to you. Then you can go ahead with power of attorney, nomination, all that. Okay. Then you should appoint an executor and trustee. Both executor and trustee should be able to handle your estate well. Executors should be in a position to actually distribute your wealth to your beneficiaries. So they need to be able, they should be able enough to go forward with your wishes. You need to draft and legalize the documents. A properly drafted will or a private trust deed is going to help you in this estate planning process. If you do not have a proper draft in place, if there are ambiguities in your drafting, it will again not serve the process of your estate planning. So it has to be properly drafted. It is better you go with some legal expert under their professional guidance. You will be able to have a properly drafted document. You need to legalize these documents. There is registration for wills is not mandatory, but I recommend you go with the registration of the wills so that it is properly legally valid in the eyes of the law, right? Then you should regularly review and update your plan. Whatever you plan for, like through your wills or your trust, it has to be regularly reviewed upon. I would suggest maybe within a span of 2 to 3 years, you should review if there is any marriage in your family or there's some birth or anything that has changed socially and you would want to have a change in your transfer requirements. So you should regularly review that and update your plan accordingly. So let us first understand will. Like what basically is a will? It is a legal declaration. Legal declaration, it is actually a formal document. It need not be made necessarily by a lawyer. Even you can go forward with a will, but it is recommended that you get it done from a professional. So to avoid any ambiguities, right? So it is must that the will must be written by the testator. It has to be signed by the testator, and there has to be signature of at least two beneficiaries, two witnesses, both of which cannot be beneficiary in your will. Okay, so if you die without a will, without this legal declaration, our laws are very, very strict about these things. Like if laws of intestacy will apply to you, which I'll be discussing further. So it is better if you at least have a will in place. Then there is this intention of the testator, that is the maker in a will. The will is basically the intention of the testator is actually the heart of the will. It is because of the testator's wishes that the will is being made. The testator wants to maybe distribute his assets, appoint a guardian for his minor child, or wants to designate someone with some responsibility. So the intention of testator is that of prime importance here. The intention of the testator has to be clearly mentioned. There cannot be any ambiguity in the same. Because if anybody goes and protests against this will, the intentions, if are clear, the court will of course go in the favor of the testator who's not present there. So if in case after the death of the testator, when this will comes legally in picture in front of the court and there are any contestants, people contesting against this will, the burden of proof will lie on the person who is contesting the will. court usually understands that this will is valid unless there is something which is very, something that does not meet the legal standards. So, like if it is something out of the box, that there are relatives and out of the way the testator is going and transferring all his assets to somebody he does not even know. So yes, that intention can be questioned by the court, but normally the court does not question the intention of the testator. It has to be again of his own property. Obviously, you cannot transfer what you do not own, right? So it has to be of your own property. As I already said, you could transfer your personal assets, your real estate assets, or your financial assets to your loved ones. The property, here I'll want to speak about this joint ownership. So suppose if you are a joint owner with someone in a property, if you do not have a will, the property will straight away go to your surviving co-owner if you do not have a will. You will have to mention a clause in your will requesting the co-owner to transfer the proceeds or the asset value to your inheritor, to the one you want the asset to be inherited clearly. Otherwise, as per the laws, it will go straight away to the surviving co-owner. And then there has to be this desire to transfer. You should obviously have a desire to transfer. Maybe at a particular stage, there could be certain percentages that you want to divide. Then maybe at if you want to give it away to your children when they attain certain age, like maybe at the age of 20, then again at the age of 25, 30. So at different stages of life, you might want your beneficiaries to have control over your assets. So the executor of the will be responsible to carry out the wishes of the testator in line with the desire of the testator, right? Now, who should make a will? Males and females, both single or having family. So all adults above 18 years of age are allowed to make a will. And I think, yes, we all should make a will, even if we own certain amount of assets. You do not want your assets to go in someone's hand, that the one you do not want to go to, right? So you should definitely go and make a will. We are all very busy thinking we are making our own wealth, but nobody thinks about deaths, right? We all think, yes, we are immortal. We listen to death every day, but we should definitely plan for our future generations, right? So make a will. Then individuals with dependent family members should make a will. If you have got any minor children or children with special ability, then you've got dependent parents, you should go and make a will for them so that their financial future is secure. Then if you have any property or you are an asset owner, then you should make a will. You've got real estate property, then a will help you to decide on who will inherit these assets. Then if you are a business owner, then you will be clear on who is going to carry on with your business in future. Now when the thing is clear in your mind, it will help that person to take that role right from the beginning, even when you're alive. So it will help them to take up that role easily. Then individuals with specific wishes for asset distribution. So you might have specific wishes that you want to maybe transfer your inherited property, ancestral property, to your maybe granddaughter, your grandson, or wife of your grandchildren. So personal assets such as jewelry or anything like that, you might want to distribute a certain people only, so that the people having such wishes should go for making a will. Then if you want to give away to society, you want to do charitable donations and all, then you should make a will. Then if you want to designate something to your friends, maybe non-relatives, the one who will caregivers in your last days, So you want to give away your assets to someone in certain proportions, maybe, then you should make a will. Then individuals with blended families. Nowadays, the social fabric of India is changing tremendously. We have same-sex marriages. People have stopped giving birth to children. Now they keep their pets as children. So you want all these things all these people to be taken care of after your death, right? So the people with blended families, like they have multiple marriages, children from multiple marriages, then you want all of them to have a secure financial future, then you should make a will. Then people with special health considerations. Suppose you are so ill and you're unable to do anything, you're unable to take on a decision at that stage or speak up of how you want to get treated. If you have a special health consideration here, then you should make a will by saying, I want to be treated in so and so hospital, I want to be looked after by so and so person. So you can mention all these things in your will. It will be a living will. So you can do that in your will. And now who cannot make a will? Of course, a minor cannot make a will because he is not in that capacity to take decisions for himself or herself. So a minor cannot make a will. People below 18 years are treated as minor in India. So minor cannot make a will. He does not own a legal capacity and maturity, of course. Then individuals who are mentally incapacitated, people who are mentally incapacitated, even though temporarily or whatever, they do not have a proper state of mind, to take valid decisions, to make a will, to understand what their assets are, whom do they want to transfer. So you cannot make a will in such a condition. If you're not mentally stable, you cannot make a will, right? So mentally incapacitated individuals cannot make a will. Individuals under duress or coercion, individuals who are forcefully made to do something, who are coerced to write something on the name of individual they do not wish to give their wealth to. So all these all this will become invalid. Because if you are pressurizing someone to do something, it is not their intention, right? So intention of the testator is a must, as we already understood in the definition itself. So individuals and under duress or coercion cannot make a will. Now, individuals who are unfit due to temporary insanity or intoxication, if you are in a drunk state or you're under the influence of drugs, then of course you are mentally distressed. You're not fit enough to take proper decisions. There will arise conflicts of interest later if you make a will in that situation. So it is better that you do not make a will in that situation. Now, what are the key points for making a will? Legal capacity to make a will. The person has to be 18 plus, that is an adult, and of sound mind to make a will. Then you should be like mentally competent, right? Then there have to be clear and specific instructions, like what do you want to transfer? You have to be very, very specific. You cannot just say in your will that rest of my property will go to so and so person. That is not clarity. So you have to be specific. You need to exactly show, like mention everybody in your will. You've got maybe 4 sons. You are giving away your property to only 3 sons. You will have to mention the 4th name as well, that you're not giving anything to him, so that no dispute is arising in future, right? So your instructions have to be very clear and specific to the point, right? Appointment of executors. The executor's role in will making is very, very important. He's going to manage your estate. He's going to pay all your dues, taxes, while managing these estate, while executing your will. So it has to be somebody you trust, right? He has to be organized, and he should be willing to take up that responsibility. You cannot force someone to be your executor, right? Then you want to have a guardian for your minor children. Suppose if somebody dies without making a will and they have got minor children, there'll be huge, like tremendous stress on the children for those custody cases and all. So it is better you make a will and define who will be the guardian for your minor children. Then to have witnesses and legal formalities, you need to have two witnesses, and both these witnesses cannot be beneficiaries in your trust or in your will. The witnesses need not know what is written in the will, but the will has to be signed by the testator in front of the witness. Okay. And all the legal formalities like notarization is also required in some states in India. So that also should be done to make a will legally valid and witnessed. Then you should revoking previous wills. Wills can be made n number of times. There is no limit on making a will. I can make a will now, again 2 years later I can revise it. But it is important to mention that you are revoking a previous will to avoid any confusion in future, right? You do not want anything, you should just explicitly revoke, like last will of mine, I explicitly revoke my last will, right? So that is to avoid any confusion and conflicts. Then there should be clarity in language. Like I already told you, you cannot just say that rest of my property will go to so and so person without having any clarity. So there should be clarity again. Then consider special assets. You should consider your business assets, as in who's going to take over your business after your death, whom do you want to go forward with your business. Then there are digital assets coming into place these days. You've got social media accounts, cryptocurrencies, online accounts. So there has to be someone to look after those assets. If you want to make a will for those special assets, then you should store your will safely. You can have multiple copies of your will, but it should be secured in a safe place. And it should be such a place where your loved ones should be able to track down on your death, right? So it should be a place, or you could even keep it with your lawyer or your executor. Multiple copies are allowed, but make sure that the original will is safely stored. And you should always take legal advice. As I already told you, it is not mandatory that you go ahead for making a will by your lawyer only. You can make it by own self, but still it is advisable to avoid any ambiguities, to consult a qualified attorney maybe, or a chartered accountant who's legally sound, especially for for complex estates maybe. So you should go forward only with legal advice. Now, what are important points for wills? Number one, probate. Now, probate, what is probate? Probate is actually a legal process of validating a deceased person's will. It is necessary for establishing authenticity of the will. It is mandatory in Mumbai, Chennai, and Kolkata, and it is mandatory only for immovable properties, right? So, if there are immovable properties involved in your will, it is mandatory to get a probate. It is a very time-consuming process, I would say. At least it takes a year or so to get the probate from the government. It is important because it will help you settle any disputes. Or maybe first of all, the dispute won't arise. If it has probate, it is registered. So when a will is validated by the court, I suppose no disputes should arise thereafter. Then you should review your will. Yes, as I already told you, your will should be reviewed regularly. It should be relevant and valid. It should basically keep the testator's current intentions in mind. If there is any death or birth or any divorce in your family, and you do not want to give away your assets to a so and so person, then you should review your will timely, preferably 2 to 3 years. Then there is registration. registration is again not mandatory but preferable because it will help you avoid disputes. It provides as an evidence in the court of law, and it will reduce any legal complications in future, right? If in case this will is contested by someone or like challenged by someone in court and it is properly registered, it will be valid. Like people could say this is a forged signature of a testator. This is not the real signature of testator. So when it is registered, there is no point in arguing, you know. It will be well established that yes, the testator has rightly made this will and this will belongs to the testator itself. Then negligible stamp duty for registration. The stamp duty for registration is very, very minimum. It will vary depending on which state you are residing in. But nominal fees is only charged for the registration of a will. Then it is highly recommended by me. And in fact, if you go to other lawyers or chartered accountants as well, they'll always tell you if you're making a will, go get it registered, pay stamp duty for registration to avoid any, to keep everything clear and secure. It is that extra security that you're providing to your will by registering it. Now, executor appointed to be preferably of younger age than the maker of the will. Here, I would say, like suppose you are the testator, you're appointing an executor older to you, maybe he'll die before you. So it is better, preferably, to have a younger age maker of will, younger age executor of the will. You do not want them to die before you, right? So it has to be someone who is younger than you, who is more capable of taking on the task. He should be able to fulfill his duties of handling the estate, applying for probate, and making all the distributions. If you have got this young executor, this probate thing and all takes on a lot of time. So if you have a younger executor, he'll be able to give you more time commitment as compared to the older ones. They've got their separate problems only. If you have an older executor, their health and all, everything will be in line to your, wishes. So it is better you have a younger executor. You could, it is not required, but you can also have a fitness certificate, health fitness certificate from your executor before you appoint an executor. You could also have alternate executors in case the executor does not want to carry on with his duties, does not want to, or in fact, even is not able to due to any of his reasons. So you should always have an alternate executor as well. Now, intestate, we understand what is intestate succession. So, after you listen to this, you are definitely going to make a will because the laws of India are so stringent. If you do not have a will in place, it is not the relatives who are going to decide to whom what is going to go, but it is this act that is going to tell whom to transfer the assets to. Now, if you die without a will, that is called dying intestate. And laws of intestacy, as I already told you, are going to apply, which are as per Hindu Succession Act listed here. There are separate laws for Muslims, Parsis, Christians. Now, if I die intestate, if the testator dies intestate, the number one priority to inherit will go to class 1 heirs, who are sons, daughters, wife in case of male Hindus, then mother, then daughters and sons of predeceased children, widowed daughter-in-law. Please note that the father is not included in your class 1 heir. Though your father might have provided for your education, for your upbringing, but the law does not classify your father as your class 1 heir. You would not want your father to not get anything from your estate. So you will obviously go and make a will now. Then it is important to note here that all your assets will be distributed equally to all your legal heirs of class 1 category. In case you do not have class 1 heirs, then going forward, the court will transfer it to your class 2 heirs. Now here it is not equally, but in the order of preference, wherein the first person is to inherit will be your father. Your father comes first, then your brother, then your sister, then your paternal uncles and aunts. Paternal uncle and aunt, your tauji, your bua, your taiji, all will get your assets if you do not have a will. So please, there are many, I think, who might not want that to happen to their wills. So go and make a will. Then, in case there are no class 1 and class 2 heirs, there'll be agnates who will be coming into picture. Now, agnates are basically, they are the relatives, male relatives on your father's side. So your the lineal ascendants or descendants from your father's side, like your cousin brother, your paternal uncles, paternal cousins, all will come in this category. All your distant relatives, I would say. Then cognates. Cognates are relatives on your mother's side, like your mosi, your mama, all will come on this side of succession, on this side of legal hair. So all of these, your mama ke bacche and your masi ke bacche, all will get your wealth in case you do not have a succession plan. And if suppose agnates and cognates are in existence, in both of them are in existence, then the agnates will get a preference over cognates. And again, in agnates, there is further, when you are more related, then you will get the more part of your wealth as compared to others that are more distant. Then adopted children. The the Hindu Succession Act does not differentiate between adopted children and biological children. Once a adoption procedure is formally recognized, then the adopted child becomes a full member of your family and he has full rights to inherit your property. Again, there can be restrictions on the adopted child to inherit from his biological parents. There can be restrictions, okay? But you can go forward with giving away your wealth to your adopted children. Government. Now, suppose nobody is in existence, neither your class 1 heirs, nor your class 2 heirs, nor agnates, nor cognates, nor do you have any adopted children, then all of your earned wealth is going to the government. If there is nobody coming forward to claim your assets, government is straight away going to take that asset. So have this will, please. Then succession certificate. Succession certificate is basically a legal document that you get from the court. It can be availed only in case of movable assets. Movable assets such as your bank account, your jewelry. You can go forward to the court. You can approach the court, simply apply there that I am the legal heir, like because the testator has died intestate. You will you'll have to go to the court and prove that you are the legal heir, and you could apply there, and the verification will be done by the court, and a succession certificate to your name will be issued if everything is okay. It is not mandatorily for all the property, but it is specifically for movable property only. Now, what will be the taxability of wills? Now, inheritance of assets via will. So if you are inheriting any assets by will, they will not be taxable in your hands. Like, it is not treated as a transfer as per income tax. So it will not be taxable on inheritance. Then again, capital gain tax, there'll be no tax, capital gain tax at the time of inheritance, But you can, of course, have capital gain tax when the beneficiary will give away these assets, like will transfer these, sell or transfer away these assets. So then the capital gain tax will arise. You will have the benefit of cost of the previous owner, that is the one who had given you the assets through his will. Then there is no GST applicable in this, because GST, as per GST, GST is applicable on supply, and with the transfer of assets through will does not count as a supply, so GST will not be applicable. Then there was this estate duty, which is long back abolished in 1985. So there is no estate duty whatsoever in wills. Now let us here we come to an end for wills. Now let us understand what are private trusts. Private trust is basically a legal arrangement wherein there is a settlor who has got some property. He is giving away that property to a trustee to manage that property and give it away to the beneficiaries. Okay, he will hold and manage these assets and give it to the beneficiaries. So there are three people involved here: a settlor, a trustee, and a beneficiary. Settlor can be a trustee. Settlor can be a beneficiary as well. But if the settlor is a beneficiary, there has to be some other beneficiary also in this trust. You cannot have just settlor as a beneficiary, because as per income tax, private trust is a separate entity. If you are having settlor itself as a beneficiary in a loan capacity, it will not be a distinct identity for income tax. All the clubbing provisions and all will apply here. So it is better that you have multiple beneficiaries. Now it is basically governed by Indian Trust Act 1882. The formation, the functioning, and the dissolution of the private trust, it will be all governed by the Indian Trust Act 1882. These private trusts are basically made only and only for the purpose of your wealth management, your asset protection, and for your family welfare. Now, let us understand the advantages or benefits of making a private trust. So, number one reason is to protect your assets from your creditors. When you give away your assets in a private trust, the creditors cannot legally claim those assets, because now these assets do not belong to you as a person, but now they have been transferred to the trust. So number one reason why people are making these private trusts is asset protection. Then you want to have continuity of income. Now there will be continuous financial support coming in for your dependents, for your minors, specially able children. So you will go forward with a private trust in that case. Now it will avoid the tedious and time-taking procedure of probate. That is also one of the advantages of private trust. Immediately all your assets are transferred to your beneficiaries. There is no need to go for a probate or anything, and you can enjoy your assets. There is a customized control. The settlor can specifically declare like what assets he wants to distribute and what proportions, like how he wants to get them managed or distributed. So there is absolute control of the settlor on this. So that is one advantage. Then there are tax benefits when the trust is properly legally structured. It will help you minimize or defer your taxation. Then there is privacy. Unlike wills do come into public picture when they go for probate, but private trust will always remain a private property. Nobody will ever come to know of it. So there remains privacy in private trust. Then there is flexibility You can have flexible purposes, such as you can use the funds of the trust for an education, for a marriage funding, or for any charitable intentions. So flexibility is also one of the advantages here. Now, let us understand what are the types of trusts. There are basically I would say 4 trusts, in fact, types of trust: specific trust versus discretionary trust, and revocable versus irrevocable trusts. It is depending on the powers and discretions granted. Now, this specific trust and discretionary trust is dependent on the discretionary power in the hands of the trustee. Now, for a specific trust, there is fixed distribution by the trustee. The trustee does not have any discretion, as in he wants to transfer only so and so part. He will have to transfer what is mentioned in the specific trust deed, private trustee. Now, in case of discretionary trust, the trustee has got full discretion over the distribution. He can say, like, obviously, he will have to give away the assets to the beneficiary. But again, the proportion, the timing, everything is in the hands of the trustee. Then the rights of the beneficiaries. Now, in specific trust, the beneficiaries have a defined right to specific assets or amounts. And in case of discretionary trust, the beneficiaries have a potential entitlement, but it's not guaranteed. So you know that I am going to get so and so amount in this trust, discretionary trust, but you do not know exactly what amount and when you are going to get it. Then the role of trustees. Talking about the role of trustees in case of specific trust, it is specifically to follow what the instructions of the testator, of the settlor are. So he has to go clearly with the intentions of the settlor. He has to follow those instructions. Then in case of discretionary trust, the trustee has full flexibility to decide how to distribute the assets based on his judgment. Protection from creditors. No special protection from creditors in case of specific trust, because in specific trust creditors know that yes, agar ye A, B, C hai, to A asset belongs to so and so person, so I can go and attach this A asset. So you do not have protection from creditors when it is a specific trust. In case of discretionary trust, you cannot say कि यार A, B, C में से कौन सा asset इसका है. So the person cannot attach your assets. It will be protected from the creditors and beneficiaries, because beneficiaries don't have an automatic entitlement to those assets. So those assets are protected from the creditors. Now, revocable trust versus irrevocable trust. Now, revocable trust, in this, the settlor retains the control and can amend or revoke the trust at any time. So there can be a clause in your trust deed, like if so and so incident takes place, all the income or the assets should come back to me, or maybe anything that puts a clause in your trust deed that the income or the asset is coming back to the settlor is a revocable trust. In irrevocable trust, settlor cannot change, amend, or revoke the trust once it is created. It will be only for the benefit of your beneficiaries. You cannot divert any of its income or your asset distribution back to yourself. It is an irrevocable trust. The tax implication will again differ in both types of trust. The assets are still part of the settlor's estate for tax purposes in case of revocable trust, because it will be purely, a tax planning. If you are creating a revocable trust, the income tax authorities will not identify the private trust and the settlor as two separate entities. It will be the one and the same entity for income tax purposes. So all the tax liabilities will have to be borne by the settlor himself. In case of revocable trust, assets are removed from settlor's estate and income may be taxed to the beneficiaries in case of irrevocable trust, because they are no longer in control of the settler. So obviously, why will the settler pay taxes on that? So it will be again be taxed in the hands of the beneficiaries. Then in case of revocable trust, there'll be no protection from creditors since the settler retains the control. The settler has control, like these assets still belong to me somehow because of that clause in the trust deed of revocability. So there will be no protection from the creditors. In case of irrevocable trust, it will provide creditors protection since the assets are no longer in the settler's estate. Then flexibility in revocable, the trust can be, the trust instrument can be revoked or altered. So there is high level of flexibility. On the contrary, in case of irrevocable trust, there'll be no flexibility because once the trust is created, the settler cannot alter or cancel it. Now, what are the key considerations for drafting a trust deed? As we understood what should be taken care of while drafting a will. Now here we'll be looking into how to draft a trust deed. Now, first of all, you will have to identify your key parties. Who are your key parties? The settler, the trustee, and your beneficiaries. The settler, of course, the one who's making this private trust will be the settler. Then the trustee again has to be, a very, I would say, person who of tremendous capability, who has this thing of managing the estate properly, who is able to properly take care of your estate and give away your assets in the trust. He's able to maybe take decisions of managing your trust, like maybe again further appoint lawyers or something to fulfill your wishes. So you should keep in mind that your trustee is someone you trust the most. Then you should have clearly defined objectives. Clearly defined objectives in a trust deed are mandatory so that you are able to exactly tell in your trust deed that whom to give away these assets to, in what proportion, at what time. Then you should properly decide upon your type of trust, as we already discussed. The type of trust being specific, discretionary, revocable, or irrevocable. There are different implications if you choose any of the trust. So keep into mind the objects that they are offering, each of the trust is offering. So go ahead with the type of trust that best suits you. Then what are the trust property and the asset management? What are the properties in picture? What are your assets? Then what are your liabilities that you have to pay off if you take over those assets? So all these things have to be properly seen before all this is carried out. Then what assets are to be managed? All has to be considered while making a trust deed. Then what will be the trustee's powers and responsibilities, or whether a trustee can appoint further lawyers, or he can take any professional help in managing your estate. Then whether the trustee has the power to maybe resign also. He could also have a power to resign. He might have power to draw funds from your trust for managing the trust. He might be he's responsible for your filing the returns of your trust, so that has to be clearly mentioned in your trust deed. You could also state like we had an alternate executor thing. You could also have an alternate trustee in case he's unwilling or unable to carry on with his duties. Then you could define the rights and duties of your beneficiaries, like what beneficiary will get what quantum of your wealth, and what duties does he have to satisfy. Like somebody can put in a clause that in the private trust deed that the child who takes care of me most in my last days will get so and so amount. So these kind of things can also be included in your trust deed. Then you have to check for your legal and tax implications, like if any legalities are involved, like what kind of like the stamp duty thing and all, if you go for registration of your trust. So what is to be done, tax implications in your hands as a settler, then in the hands of the trustee, and then in the hands of the beneficiaries. All of this has to be considered before making a trust deed. Then you have to check on the risk and compliance checks, like if you have to make any filings with any authorities, you have to check all that. All the compliance checks have to be done. If there is risk involved in making this trust deed, you have to consider that as well. Then there has to be a dispute resolution mechanism in case any disputes arise between the trustees and the beneficiaries at any stage. Then you should have a proper dispute resolution mechanism in place, like through arbitral or something like that. So that has to be there to avoid any conflicts in future between the trustees and the beneficiaries. Now, let us understand the taxation of private trusts. I'll be speaking one by one, like section wise. Now, section 160 of the Income Tax Act is specifically talking about the representative assessee. In case of a private trust, the trustee is responsible to file the return in the representative capacity. So representative assessee here means the trustee. He is liable to pay tax, and he has to ensure that there is continuity in tax assessment even when beneficiaries change. Okay, so trustee is the whole and sole responsible person here. Now, section 161 talks about the taxation of specific or determinate trust. Now, when we have specific trusts, so the beneficiaries and their shares are clearly defined in the trust. So the income of the trust will be taxed exactly as per the slab rates applicable to those individuals. Okay. In case if any of the beneficiary is having income of above the basic exemption limit, the trust will be charged to tax at the maximum marginal rate, that is MMR. In case of section 164 speaks about taxation of discretionary trust. Now, in case of discretionary trusts, the income distribution is not defined. The trust exactly like who will get what. So here the taxation will be at MMR. Currently, in the new regime, it goes up to a maximum of 39%. In the old regime, it was around 42.744%. But in new regime, it is maximum to the extent of 39%. To ensure tax avoidance strategies can be, formed, like you can always select which type of trust you want to go forward with, whether a specific or a discretionary one. Then section 166 talks about direct assessment of beneficiaries. Here the tax authorities will directly assess the beneficiaries. They will not bother the trustees while assessments. This will ensure flexibility to the tax department in tax collection. So this talks about direct assessment in the hands of the beneficiary itself. Now, section 60 talks about clubbing of income. Well, if the settler revocably states that so and so income should come to me, then that income will be clubbed in the hands of the settler, because that income cannot belong to the trust when a revocability clause comes into picture. So that income will be clubbed in the income of the settler, because many people try to prevent, tax liabilities. They are doing tax evasion in this case to maybe come into a lower tax bracket and all. So income tax is very smart in that. The authorities are very smart. They club these incomes in the hands of the settler only. Then section 61 talks about taxation of revocable trusts. If a trust is revocable, it will get clubbed in the hands of the settlor. No taxable liability will arise to the trustee or to the beneficiaries. Then section 62 talks about taxation of irrevocable trusts. Now, if the trust is irrevocable, the settlor cannot reclaim those assets or the settlor cannot reclaim those incomes. So obviously, the income will be taxed in the hands of the trust or the beneficiary, depending again on whether it is specific or discretionary. Then in case of section 56.210 tax talks about transfer of any property without adequate consideration to any person. So in that case, if you are transferring any property without any adequate consideration to someone, the people will be chargeable to income tax under the head IFOS. There is a specific exclusion to this case when you are transferring, that is, when you're transferring for the benefit of your relatives, this thing will not trigger. 56.210 will not come into place. So when the beneficiaries involved here in the trust are relatives, it will not be treated as an income. It will not be a deemed income. So that is an exemption. Then again, for, I would say, each head of income, the taxation will differ. In case of private trusts, when it is your, I'd say, house property income will be charged as per your slab rate. In case of specific trust, with a deduction of 30% under section 24B. And in case of discretionary trust, it will be charged at MMR, but you will get the benefit of 30%. Then in case of IFOS, MMR, in case of in case of discretionary trust, and in case of specific trust, it will again go in your slab rates. For capital gains, it will be short-term and long-term. It will be same. The rates of short-term taxation and short-term capital asset and short-term capital gain and long-term capital gain will apply in both the scenarios, like in case of specific trust also and in case of discretionary trust also. The current rate of short-term capital gain tax is 20% and long-term capital gain is 12.5%. So it will apply the same to both kind of trusts. Okay. Now let us have a comparison between will versus trust. Now there are different features on the basis of which I have compared the wills and the private trust. Here, in case of wills, there is confidentiality. Oh, sorry, I think I've interchanged the headings, but the privacy is maintained the most in case of private trust, because it is a, very, this document is not disclosed in public. So private trust will have this confidentiality. In case of wills, they have to go through the probate, so it will get disclosed in front of the others. Now, in case of wills, there will be potentially lower tax burden for direct transfers. As we already understood, there is not much tax implication in case of wills. Then in case of private trust, there will be a higher tax burden. There is a higher burden as much as 39% or 42.74% in case of old regime. So you're taxed at an MMR. Then the execution speed in case of wills is quite delayed because of the probate, which is a time-consuming process. And in case of private trust, it is immediate upon the trust creation. Then in case of private trust, the asset protection is very strong via ring fencing, as in the creditors will not be able to claim your assets. In case of private trust, specifically if they are discretionary private trusts. So there is this ring fencing which will allow to protect your assets from the creditor's claims. Then in case of wills, it is limited or vulnerable until it is distributed. The distribution takes a lot of time in the will. So till then, your assets are always at risk of getting transferred to your creditors or anything. Then the admin cost involved in case of wills is very low. The basic drafting and the probate cost is not as much as that of the private trust. In case of private trust, the cost is high. There have to be regular compliances to be done, filing of returns, then all this maintenance of documents and all that. So the admin cost involved in case of private trust is a lot high. Wills, I would say in case of complexity, the wills are suitable for straightforward asset distribution. When you've got clear assets, you've got clear, like, limited family, not many people who are going to come forward to claim your assets and all, you can go forward with wills. In case of private trusts, where there are complex estates involved, where there are contingencies involved, you should go for a private trust. Now, let us talk about real life scenarios where in this whole thing of will and private trust may trigger. Now, in case there is a family property dispute, suppose two brothers are fighting over the property of their dead father. So this dispute could have been avoided had the father put up a will or had the father created a private trust. So this thing is very common in India. People do fight for property within the family. That could have been avoided if the father had a proper succession plan in place. Then business succession conflict could have been avoided if you are into a business, well-grown business, and you've got two or more sons, like any of them, both into your business. So you might not want both of them to, success your business, to inherit your business. So if you would have made a proper will, or if you would have made a proper trust, you could have avoided that conflict between those brothers. Then there is this nomination versus legal heir issue. This is a very, very, in fact, not many of us know that this nomination is not the same as legal heir. Like, nominee, as per the Indian laws, is considered only as a custodian of your assets. Like, many of us have a nominee in our bank accounts, in our demat accounts. So we assume after our death, all the balance in our bank accounts is going to our nominee. But no, that is not the case as per the law. The law says that nominee is only and only a custodian. So the custodian has to collect these assets. So he'll have to collect these funds from the bank, and he will have to properly give it away to your legal heirs. Your nominee cannot claim your assets. The nominee does not have that power. Okay. So in many cases, there have been issues where nominees come up and to claim those, or to claim ownership of those bank accounts. But in long term, they will obviously lose on this battle. So it is better, if you are appointing a nominee, it is better you appoint a legal heir as your nominee. Do not differentiate between the two to avoid any conflicts later on. Now, dispute over inherited ancestral property. There are multiple generations who are conflicting claims over inherited property and all. So in this case, HUF kind of structure can help to distribute assets equally to avoid legal battles. Then guardianship of minor children. Here, minor children, suppose both the parents of minor children are dead, then there could be fights in the court for their custody. So if you want to avoid that kind of thing, you should have a will and put up the name of your guardian whom you trust the most with your kids, right? So that is also an important, a very practical example I would give here. We all, I would not name that, but all of you are aware of a very visionary industrialist who has a multi-billionaire conglomerate. He was into into retail, finance, telecom sector, and but he failed to do one thing. He did not do succession planning, which led to a lot of dirty conflicts between their kids, boardroom conflicts, all was there, which had shattered the confidence of the shareholders. But I am very confident now, learning from the mistakes of the dead father. This current generation might have already planned their succession planning well through any of the tools we already discussed. So it is best for all of us to have a structured approach to your wealth and business transition. You should go forward with your succession planning right away. And to conclude, I would say proper succession planning is not just an option, it's a necessity. Because you do not want to fall prey to the Hindu Succession Act, what it states, like if you do not want to go ahead with the sequence offered by the Hindu Succession Act, the class 1, class 2, whatever is given in there, so you should go with a proper succession planning. It is not a necessity, please. Sorry, it is not an option. Please, please, please go and do your succession planning right. Thank you everybody for joining us today. It was really a pleasant experience to be a part of this platform here today, to contribute on this platform. I would thank Mr. Vaibhav to be for giving this opportunity.
Yes. Thank you, ma'am, for your presentation and explaining topic in simplifying way. So now I request all the participants and delegates, if you have any question, you can unmute yourself and ask directly to the ma'am, or you can put your question in the chat box also. I think, ma'am, there is a question from our Sumit Katare, sir. So please welcome Sumit, sir.
Hi, Bijal ma'am. Amazing insights, amazing presentation, good orator skills, amazing. It was, I actually missed the first bit of your presentation, but it was amazing. I'll go back to the recording and refer it. I have two scenarios, ma'am, and I'd request your insight on those two scenarios. Scenario number one is there is a company which is a proprietorship concern by two partners. Now, once you dissolve and they own a property, okay? Once the company dissolves, does the society transfer that property to both the owners?
It is held in the partnership firm.
Yes, it is that the property is held in the partnership firm and they dissolve the partnership. So does the society go ahead and by virtue of the dissolution deed, does it put the share certificate into two individuals' name from a company name?
So when you go forward with the dissolution, you will have to exactly state who takes away that asset. So if
okay.
either
In the
of the
dissolution
partners,
deed, because it's a typical partnership company, and the old school of it's in the Shop and Establishment Act, so they've just gone ahead and dissolved the company. So from a society per se perspective, does that property get transferred to the owners or the promoters or proprietors of the company in their equal proportion, because that's where they held it? So that company was by two partners and their partnership deed was clearly 50% each. And after they dissolve it, we've referred that.
here I would like to say that partnership firm cannot specifically hold a property because the laws do not identify. Hello, hello, are you there, sir? Hello. 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 Yeah.
I apologize. I
Yeah.
lost connection.
Yeah.
Sorry.
Yeah. No problem. Yeah. So, sir, the partnership cannot
One
hold
second, ma'am.
any
One second,
property
one
in their
second, one
own
second,
name,
one
sir.
Yes, ma'am.
Yeah. Sir, the partnership cannot hold any property in its own name. It might be in the name of either of the partners or jointly in the name of the partners. It will not be specifically in the name of the
But
partnership.
ma'am, हमारा जो property है ना, that is held in the society records under the company name. In the society records, it is already held under the company name. So the first share certificate which has been issued by
Okay.
some predecessors, it is in the company name only. And now they
Okay.
came up with this claim that, okay, we've dissolved that partnership and that partnership is not there. And the company has been, diluted. So we want you to transfer the share certificate on two names. So is legally, it should be okay, right?
Yeah, that is okay.
Okay, I
Because
have,
there were two partners, you've
correct.
got dissolution deed
Perfect.
in hand. You can always submit that dissolution deed and claim the equal rights of
Perfect.
both the partners.
Perfect. Second, ma'am, we run a old age home and we specialize. It's called Sanidhanam, and we run a old age home with basically old age people and CP. CP is cerebral palsy, adults with disabilities. Now
Okay.
these guys are attached to us for life. So what is the best way? Is because there are a lot of concepts floating around in the market. Ki private trust kar lo, wo better hai. So your trustees. But then trust and the parents also feel that trustee jisko banayenge, obviously because a person with disability with mental challenges will may not have the right decision making power. So parents are a little scared. So what parents do is normally they are a little confused of what after them and how do they leave it. Do we have any right way to go ahead, whether we make a private trust, because again private trust they will have to make some trustee, and then obviously the trustee would be a family member or who they're not very sure about. So what's the right way to constitute something like this for us, for them, that after them the kids are taken care by an organization where they're posted?
Private trust is definitely a go-to option in this case. You
Okay.
could have a lawyer in case you do not trust anybody in your family. You could have a lawyer appointed as an executor, or in the case of trust, you can have him appointed as your the person who will administer your estate. So in case you're not trusting anybody in the family, lawyer is a go-to option. You can definitely go to a private trust.
But do you think a private trust is a better option than willing something on the kids, or
Sir, if here your estate is very complex, then private trust is the best option. If you've got simple assets like only you've got jewelry and all, if not much immovable property and all is involved, then
in the will?
you can go with will. Will is again sort of very time consuming process. Like when
I
you go for probate and all, it will take you at least a year, and all those court ka dhakka khana ye wo. So it is better you go for this private trust thing.
Ma'am, and again, I'm sure you would have covered it in the part when I was not there, but a will needs to be probated or it doesn't need a probate. What's the right track? Because for the will also there is a lot of confusion. Yet, if you're under HUF and you have a simple succession plan that you've got only one kid, so obviously everything goes down the line. So do you need to just make a will? You need to register a will, or you need to notary register a will, or you need to probate a will. So there are many floating concepts. What's the right thing?
Okay. Sir, I had already covered it in my presentation.
I'm sorry I said that.
No,
Yes.
I'll just repeat it for you. Sir, registration is not mandatory in case of a will. but
Right.
it is recommended that you go and register your will to avoid any complexities or conflicts later on. It will also be a, legal validity will be there when you register a will, because there are lots of, chances of people forging a will.
Correct. So
So
registered notary is good enough?
registered, yes, it is good enough, but it is
Oh,
not mandatory.
okay, fair,
And
fair.
yeah, but probate is mandatory, wherein immovable properties are involved in states of Maharashtra, then in Chennai, and so it is mandatory. It is state specific.
So, ma'am,
Probate is state specific.
in cases after suppose I will and I'm no more, and then that probate is being done, it takes a lot of time to get that probate done,
Yeah,
almost close to about a year or 2 years after a
right,
person is not there. So
right.
the right thing is to do a probate upfront while a
No, sir,
person
it cannot
is
be done upfront.
correct. But then
It
that
will come
procedure
into execution only when the testator, that is the maker, dies.
dies. Correct. So that takes almost about 1 year, sometimes
Ye-
7 months, sometimes 8 months, sometimes 1.5 years in the legal debacle. Till then, the properties and the entire thing is kind of stuck. So
Right.
is there no upfront mechanism that without probate and while you're there you can do something so that it acts as a probate and then it's a default probate? There is no
No,
such scheme.
there is no such scheme in rules.
Perfect, perfect. Thank you so much, ma'am. A lot of insight. I will definitely connect with you in person, and I really enjoyed the session, and I'm sure the others here also would have had amazing takeaways from your session. We look forward to hearing more from you in many such sessions, ma'am. Amazing.
Thank,
Honored to have you on our platform.
thank
Thank
you
you.
so much, sir. Yeah.
Vaibhav, over to you if there are any other questions.
Thank you, sir.
Sir, I would like to add here, you
Yes.
could also have this gift thing done before
Right.
you die.
Okay.
In case like, but again, it has its pros and cons. There is this stamp duty thing that will come
Correct.
up in case
Correct.
of immovable property, which is again, there is a, some, there is some sort of concession in stamp duty rate in case of gifts. It will again depend on state to state where you are having the immovable property and all. So gift is an option.
Right.
If
Right. Right. And in the gift deed, it is 0.3% stamp duty or it is the 6%. So what does it work on
it's
in
the
Maharashtra?
six, in
6%.
Maharashtra, it is 3%. Yeah,
It's 3%.
six,
Ah,
3%.
okay. 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 Okay, ma'am. I
Madam,
think there is a question in the chat box and someone is talking. Thank you so
Yeah,
much, ma'am.
thank you, sir.
Thank you, sir.
thanks for a very informative session. Want to ask, can husband and wife make a joint will?
Sir, both of them can definitely make a joint will, but it is preferable that you have a separate will, because two individuals, both of you have two separate sets of assets. So it is preferable that you can you go ahead and make a separate will for both of you.
Thank you.
Yeah, ma'am, there is a question in the chat
In the
box.
chat box.
Yeah. Okay. So
In will is required
no,
to
you need to mention each and every asset and property that you hold. And I would also recommend that you mention each and every family member's names in the will to have that clarity. क्योंकि कल को ये झगड़ा नहीं होना चाहिए कि यार मेरे चार बेटे थे, मैंने सिर्फ दो का ही नाम क्यों लिखा इन द डीड. You will have to clearly specify मुझे बाकी दोनों को कुछ नहीं देना है. So it is preferable you write all your assets in the will. You write names of all your family members in the will. That's it.
okay. Thank you, ma'am.
Yeah.
So I repeat, if anyone have any question, you can ask directly to the ma'am,
Yes,
or you can put in the
intellectual
chat box.
property can be included in your will. Intellectual property is also an asset, so it can be included in the will.
Ma'am, we can wait for another few minutes if anyone have questions.
Yeah, sure.
I urge everybody, if you all have any questions, get them clarified. You can put them in the chat box if you're more comfortable. I think no more questions, ma'am.
Okay.
Over to you, Vaibhav.
Okay,
Thank you once again, ma'am. Appreciate.
Thank you. Thank you so much.
So, thank you, ma'am. Thank you, sir. So, can we move ahead, ma'am?
Yeah.
Okay. So ICS is pleased to provide you all its research and development integrated management system, that is QMS, EMS, and OHSS. Excellence in education management. ISO made easy in Gujarati, Marathi, Telugu, and Hindi. For reading any of the above book, please contact me, Shushma Kindalkar, on the given contact details. Feedback form. Please register on www.sadgunsang.org and go in your login and give your valued feedback to us. So thank you, Vijay ma'am. Thank you all the participants for being a part of today's Sadgun Sir. Now it's time for official close the session. Thank you everyone. Have a nice day.